Dear friends, welcome back. This is episode number 2. And what about the nature of the Limitation Act? It is an amending and consolidating statute. It provides for all contingencies it deals with. There is no scope for engrafting any exception on the rules under the Act on the ground of hardship or on necessary implication. Hardship is out of place. Equitable considerations are out of place. In construing the provisions of the Limitation Act, equitable considerations are out of place. That is AER 1962 Supreme Court 1716. 62 Supreme Court 1716. Now what about the fixation of the period? Is it not arbitrary? Anybody may think, why not? Instead of 3 years, why not 3 years, 1 day? Or what will happen if 1 week is also elapsed? Nothing is going to happen. I have to get the money, I have to get the property, or I have to exercise my right. Of course, you have prescribed a period. See, 1 week elapses. 1 week's delay. What will happen? Would the heaven fall down? That is a question. Then there is an answer. If it is 1 week, all right. What about 1 year? What about 2 years? How do you draw the line? And your opponent, how many years he has to wait, thinking that you may file a suit? What is the ultimate period? If the court has power, to condone delay 1 day, court has power to condone delay 1 year, even 10 years, no harm. So what is the time up to which the other party has to wait? So everything should not be in a fluid state. It must be certain, clear. The fixation of the period of limitation is to some extent arbitrary and may frequently result in hardship. I am reading from a Supreme Court judgment. Even then, it is to be construed as the language of the statute in its plain meaning imports. The courts are not concerned with the policy of the legislature or with the result in giving effect to the language used. AER 1972 Supreme Court 1548. The court should not take into extraneous considerations such as hardship in construing the provisions of the Limitation Act. Hardship that may be relevant were in areas where the court has discretion. In the matter of condonation of delay in filing an appeal, court may consider what will happen. Hardship will occur to the party. That will be taken care of, but not for filing a suit or filing an execution petition. Now, some more decisions also on that point. I sorry. I said that it is not an exhaustive code, and I also cited AER 1964 Supreme Court 227. Now, what is this in substance? You have prescribed a period of limitation for 3 years, 12 years, 30 days, say 30 years. Vis-a-vis the remedy, what is the legal effect? See, I have to receive money from you because I have lent money to you. Normally, the period of limitation is on the basis of agreement, document, check, etc. 3 years. 3 years are over. What about my right to receive the money? or it is permanently lost, it is true that I cannot file a suit. My right is lost. My remedy is lost. My remedy to file a suit is lost. What about my right to receive back my money? It is not lost. It is, for example, you have taken a loan from a bank. You have fixed deposits also in the bank. On the loan taken by you, for filing a suit for the bank, the period of limitation is over. So the bank cannot file a suit against you and recover the amount. What about the right of the bank? To receive the money, that right is not lost. And your fixed deposit matures, that money is to be paid to you. Bank can realize the barred debt from that fixed deposit. Why? Because the right of the bank to receive that money is not lost. Only remedy is lost. So that is a distinction. Limitations bars remedy, not the right. That is a general principle. And there are methods by which the amount, or see, 3 years period is the period of limitation. 3 years are over. Cannot the borrower and the debtor agree to have some time to pay back the money even after the expiry of 3 years, that period? Cannot they enter into an agreement? Is that agreement void? No. That agreement is not void under section 25 of the Indian Contract Act. It is not void. Now, I said that the limitation bars only the remedy, not the right. Not the right. There is an exception to that theory. That is in the Limitation Act itself. That is section 27. 27 of the Limitation Act. We will deal with it in detail, but by way of introduction I am saying. Section 27, Extinguishment of right to property. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. I shall read once again. At the determination of the period hereby limited to any person for instituting a suit for possession of any property, his right to such property shall be extinguished. This is an exception to that rule that the limitation bars only the remedy, not the right. How it happens? There is an item of immovable property belonging to me. I got title, clear title. You trespassed upon the property and started possessing it adversely to me. Going by Article 65, the period of limitation is 12 years from the date my right to get recovery of possession will become barred on the expiry of 12 years from the date on which you start prescribing adverse possession. That is to some extent a complicated area. We will deal with it in great detail. Or a suit for possession under Article 64. Period of limitation is 12 years. Not based on title, suit not based on title, but on previous possession. Article 64, 12 years over. See, take it that I do not have clear title to the property. I have got only possessory right. Property belongs to X, but I am in settled possession for the last several years. While so, you trespassed upon the property and dispossessed me. I can get back the possession from you. The period of limitation under Article 64 is 12 years. 12 years over. I did not file the suit. My right to the property itself will get extinguished. Why such a provision is there? In respect of property, immovable property, particularly, then it should not be kept in suspense. There should be an honor for the property. Revenue is to be collected. There are certain other restrictions also. Tax may be there. Corporation tax, municipal tax, panchayat tax. From whom it should be recovered? Or during some period it was a paddy land, there was levy of paddy to the government. See, the owner had to measure a particular quantity of paddy to the government on a price fixed by the government. That period is over. That was at the time of the scarcity of food articles in 70s, 60s and 70s. See, all these are obligations which an owner has. An owner has right also. So there must be certainty with respect to ownership. It should not be in a fluid state. So the right itself will get extinguished in respect of matters mentioned in section 27. This is an exception to that. Limitation only bars the remedy, does not extinguish the right. That is a general rule. The right continues to exist even though the remedy is barred. However, there are special exceptions to which, on the remedy being barred, the right itself is extinguished. For example, section 27 of the Limitation Act. Except in cases where the right itself is extinguished by lapse of time, the remedy alone is barred. For example, a debtor may pay a time-barred debt and he cannot claim it back on the ground that it was a barred debt. Similarly, when a debtor has several debts, the creditor can adjust the payment made by the debtor towards even barred debt, unless he specifies to which debt it belongs. Say, I have several debts, I owe several debts to you. One debt is barred. I did not specify while paying certain amounts to which debt it should be discharged. It should be adjusted. So you can, while adjusting, you can adjust it that towards the barred debt also. A barred debt may constitute a valid consideration for a fresh contract. Section 25(3) of the Indian Contract Act. So all these things are there. That is a general principle that limitation bars the remedy, not the right. The exception we have to find in section 27 of the Limitation Act. Now, whether the limitation bars a defense? No. Generally speaking, limitation ordinarily does not bar a defense. Now, I will cite some decisions for your convenience, for your application. AER 2002 Supreme Court 960. Parallel citation 2002 3 SEC 676. Srimant Shamrad SHAMRAD Suryavamshi versus Prahlad Bhairoba Suryavamshi Bhairoba BHAIROBA Suryavamshi. The principle laid down there, law of limitation does not apply to a plea taken in defense. by a defendant, even though that defense has a claim by him, may not be enforceable in a court since the claim being barred by limitation. Thus, the Limitation Act does not extinguish a defense, but only bars the remedy. Since the period of limitation bars a suit for specific performance of a contract, if brought after the period of limitation, it is open to a defendant in a suit for recovery of possession brought by the transferor to take a plea in defense of part performance of the contract to protect his possession, though he may not be able to enforce that right through a court. Specific performance, as you know, it can be the buyer or the seller can enforce it by a suit for specific performance of contract. Period of limitation is also provided. I agree to sell my property to you. You have paid considerable part of the consideration. You are put in possession of the property in part performance of the contract. You are enjoying in possession. You are continuing in possession. I could have filed a suit for specific performance of contract and compelled you to accept the sale deed and to pay the balance consideration to me. Likewise, you also could have filed a suit to compel me to execute the document in your favor and to complete the registration and all the formalities. Both parties, either me or you, has that right to enforce execution. So, property belongs to me. I agree to sell it to you. You are put in possession in part performance of the contract. You are continuing in possession. I did not file the suit within time. You also did not file the suit. What will happen to your possession? Title belongs to me. Title belongs to me. So I can recover title. I can recover the property from you on the basis of my title. What is the defense that is available to you? Part performance of the contract. Section 53A of the Transfer of Property Act. That defense is not barred. So the limitation bars your remedy to file a suit for specific performance, but does not bar your remedy, does not bar your right to plead part performance of the contract and claim for that protection. Part performance, you are aware, Section 53A of the Transfer of Property Act. It can be used as a shield, not as a sword. All those things we have studied. 53A. Please see that decision 2002 Supreme Court 960. 2016 5 Kerala High Court cases 942. Division Bench, Kerala State Bamboo Corporation Limited versus P.K. Rameshan Nair. Limitation Act bars the remedy but will not destroy the right to recover the debt. That is the principle. Now, AER 1992 Supreme Court 1815. 92 Supreme Court 1815. Punjab National Bank and others versus Surendra Prasad Sinha. I will read a very short paragraph in that judgment. Section 3 of the Limitation Act only bars the remedy but does not destroy the right which the remedy relates to. The right of the debt continues to exist, notwithstanding the remedy is barred by limitation. Therefore, when the principal debtor did not repay the bank loan, the bank as a creditor can adjust it at a maturity of the fixed deposit receipts deposited by the guarantor with the bank as security. though the debt became barred by limitation at the time of maturity of the fixed deposit receipts. It is not obligatory to file a suit to recover the debt. So the remedy is barred, but the right to receive back the money under the transaction is not barred. That right is not lost. Then 2001-4 SEC 713 parallel citation AER 2001 Supreme Court 1968 Syndicate Bank versus Prabha D. Naik. It is held that it is a procedural law, Limitation Act. Then AER 2002 Supreme Court 960, which I mentioned to you, Srimant Shamrao Suryavamshi and another. Part performance, which I mentioned. And this is the principle. Limitation only bars the remedy, not the right. That is a general principle. Exception is there under section 27. Now, the Limitation Act applies to courts, no doubt about it. No doubt about it. But does it apply to tribunals, quasi-judicial authorities and executive authorities? No. Unless it is specifically provided. So there is a special statute which provides for a forum to decide the disputes between parties. Some tribunal. For a particular type of proceeding, a period of limitation is also provided. Or appeal or revision, whatever it is. But there is no provision for condoning the delay or application of the principles of Limitation Act. Particular provisions of the Limitation Act. Would the provisions of the Limitation Act apply? The answer is no. At the same time, under the special statute, a right is created, a remedy is also provided, and that remedy is in court. To a proceeding in that court, would the Limitation Act apply? Sections 4 to 24 of the Limitation Act. That is 4 to 24 of the Limitation Act. Let us take it that. That is, you will get in the various provisions here. 4 to 24 of the Limitation Act. Would it apply? It will apply unless it is excluded. So this principle you have to bear in mind, that the Limitation Act should not forget it. The Limitation Act applies to courts and not to tribunals or quasi-judicial authorities. If a special statute provides for a remedy before a civil court, even though nothing is said in the special statute about the application of sections 4 to 24 of the Limitation Act, those provisions will automatically apply. If that proceeding is before a tribunal, if nothing is provided about the application of the Limitation Act, then the limit is 4 to 24 of the Limitation Act will not apply at all. That is a distinction. A proceeding in a court, a proceeding in a quasi-judicial tribunal or a quasi-judicial authority or an administrative authority, executive authority. If it is a court, for example, the Indian Telegraph Act, an electric line is drawn, trees were cut or property were taken, there is a dispute. Section 16 of the Indian Telegraph Act provides for a proceeding before the district court. Would the Limitation Act apply? It would apply. But if it is before a land acquisition officer, would the Limitation Act apply? No. For example, land forms legislations are there. Rent control legislations. Where for filing an appeal, a particular period is provided. And there is no provision for condoning delay, application of Section 5 of the Limitation Act to that authority, which is not a court. Then Section 5 will not apply. On the other hand, even if it is a quasi-judicial authority or a tribunal and any of the provisions of Sections 4 to 24 are made specifically applicable to proceedings before that tribunal or quasi-judicial authority, then it applies. Then only it applies. On the other hand, if the special statute does not provide for anything about the Limitation Act, but that proceeding is in a court, then notwithstanding that you have not said anything in the special statute about application of 4 to 24, those provisions will automatically apply if they apply. This is in short the principle which you can't afford to forget. We will meet in the next episode.